answer questions that's been posted to me through the internet or email as to legal questions into the areas of law that I practice. I'm primarily an employment business law attorney, but we also do landlord, tenant, family law, and especially contracts. This is a wonderful opportunity just for me to answer questions, not to really give legal advice or tell you if you have a case or what your strategy should be. So it is just an opportunity so that you can understand a little bit more about the law. I have gotten several questions, which I'm very thankful for, since this is and I am thrilled to do this at this time. We have questions in regards to business and employment law, landlord, tenant, and even a family law case. One of my first questions that I got online was, I'm a new employer, and I am wondering if I need workers' comp for myself. Well, that is a great question for a new business and a new employer. It sounds as though it's just not yourself. It is sounding like you have employees. So it would all determine on the industry that you're actually doing business in, and that information I don't know. So that could be a strong possibility, yes, especially if you have over 4 employees. However, for yourself, you can actually file what's called an exemption. It's quite easy to do, and I actually highly recommend it for all members or officers in corporations or limited liability companies. This exemption basically excludes you from being counted as a part of the work comp employee count in regards to liability and for your establishment of your premium. It's a simple process. You can go online to the state of Florida's website, and you can do it completely online. It's just you're going to attest of what your position is with the company, that you are an officer or a member, and that you're declaring that you want to be exempt from the matter. You can renew it, you can remove it, you can do it any way you want to, and it's not a hard process, but it is a process you have to do. If you fail to do the exemption, if you fail to get workers' comp or are required to have workers' comp, you will be deemed as an employee under the compensation assessment, and there could be penalties for you for failing to have it. Like I said, it's not a hard process, but it is one that I encourage most new business owners to do. I also encourage new business owners and employers, as soon as you hire your first employee, to get at least a quote on workers' comp, and especially if you're not in construction or one of those required businesses that automatically require workers' comp. It's a good technique. While it is a new liability or a cost, it can save you in the long run if there is a workers' comp accident, and those matters are handled by the insurance carrier versus you if the claim is made. So that was a really great question for a new business owner, one that we get often here at Riggins Law Firm. So I appreciated that today. The second employment law and business question I got was from an employee who is a supervisor. And in her question, she raises a good point and a good issue. She is a manager for several years, and during her recent management, she came across that other managers and directors were unfortunately breaking the law in regards to theft, falsification of documentation, and seems as straight thievery. Unfortunately, when she reported this, higher management was not susceptible to listening to her and honestly believed that she was making false accusations. During her employment, she continued to investigate it and actually sustained and acquired actual proof of the illegalities of the other management's activities, which now management knew. Unfortunately, due to her continuing the investigation, they fired the employee, and she wanted to know that she had a possible cause of action. From what she described, it seems as though she did discover that it was a known breach of the law of what these alleged other directors and supervisors were doing, and she properly reported it because she reported it to her upper management in an email, which is a writing. Florida has a great law, which is called Florida Whistleblower. It has a private act and a public act. And under the private act, which is employer seems to be, it requires several actions or acts by the employee who is seeking the protection. One of the things is that you have to, in writing, tell the employer that you object to the activities of the illegalities and basically advise them that you won't participate and you want them to stop the actions. It doesn't have to be you don't have to do a long letter from an attorney, or it doesn't have to be very wordy. It just has to be to the point that you believe or definitely know that someone has broke the law as a part of the company's actions, and then report it to management or to a supervisor, CEO, director, to whomever, and you want it to stop and you will not help the person or do anything in it. If once you do this writing, they actually retaliate or try to fire you or try to ask you to cover it up, or harm you in a way, damage you, suspend you, reduce your pay, demote you, you may have a strong cause of action in regards to this matter. You can also be a protected whistleblower by reporting it to law enforcement or an agency, a governmental agency that has the authority to actually enforce whatever illegality has occurred. That is another way of doing it. The law is very hard in this regard. There's been several cases going back and forth on the matter to make sure that what is being reported is truly illegal. There's been cases law that basically says the employee just has to reasonably believe it's illegal. However, that case law is fading away here in the state of Florida. So I always advise people, make sure that it actually is a breach of the law or some type of illegality that's happening. From what she's reporting, stealing, no matter how you look at it, is technically against the law. So that was a great question. My advice to you is to follow the Florida statute and report it and tell them that you object to it. And if not, just call law enforcement to have them investigate it. My last question in regards to employment law matters was from an employer. And the question is in regards to overtime. And it basically says, do I have to pay my employees overtime for work above 8 hours or 40 hours? This is, overtime is both a state and federal law. Under the Fair Labor Standards Act, an employee is entitled to time and a half if they are non-exempt and they have actually worked over 40 hours. So it's not the 8 hours per day if that's what they're a full-time employee. It is actually, if it's 40, then the plus. And that means actual work. Sometimes employees and employers get confused. They may take, let's say they had a doctor's appointment and they took 2 hours off. They got paid for the 2 hours because they used their paid time off or their PTO. And so they were at 40, and then they worked another hour over. Since they didn't actually work the actual 40 hours, they're not entitled to the time and a half, or the halftime for the 40 hours. They're only entitled to their straight time. Maximum hours or overtime isn't entitled to actual work. With the holidays coming up, that question comes up a lot, because a lot of times offices are closed half a time for the holiday or a whole day for the time, and they still pay on those matters. Even if you're paying them for the holiday, the question is work. And basically, work is that you are doing something at the benefit of the employer. If it wasn't for the benefit of the employer and it's just a benefit to the employee, time off or holiday pay, overtime is not required. What if the work week is a 36-hour week? It doesn't matter. If you can have 35, 36, 30 hours, and they work, let's say you have a 36-hour work week and they work 37, 38, there's not overtime for the 2 extra hours. Both state and federal law requires that the hours be over 40. Now, there's a difference in regards to exempt or non-exempt, but this seems to be more implying as to just a regular hourly paid employee. What I always warn employers is when they put someone on a salary trying to avoid paying overtime, it's still a requirement as to what type of work they're doing before you get out of actually having to pay the halftime for the overtime. But that was my last employment law question, which is a great question for this time of the year, especially with the holidays. I then got a question in regards to family law. In this question, I have a scenario where I have a parent who was in a divorce in another state that actually got the original divorce decree domesticated or recognized by the state of Florida. At the time of the divorce, both parents were actively and paid quite well in their prior jobs. However, upon moving to Florida, there was a high increase in the mother's pay, but a lower decrease in the father's pay. And the mother was awarded the majority time sharing of the children. Therefore, the child support was reduced in regards to the obligation of the father. However, the father is now making equal or more than the mother, and the question is she entitled to an increase? Under Florida law, depending on if you are filing or the Department Department of Revenue is filing, as long as there has been a substantial change, depending on who's filing, either the agency or yourself, as long as that can be proved, and a substantial change is normally 20%. And if that can be proven, then yes, I would encourage any parent who's looking to either increase or decrease, because it works both ways. If there's been a change for a lowering of amount, say, unfortunately, let's say you're hit bad times and you're down to minimum wage or no wages, you can ask for a decrease in child support, as same as you can ask for an increase in child support. This process is done by what's called a supplemental petition, in the same case that originally established the child support, and it would normally be determined by a hearing officer and finally by the judge if there has truly been a situation where child support does need to be reduced. In my final, got two more. We have two more questions, and they're in regards to landlord-tenant matter. In this case, I have a scenario where a husband and wife unfortunately split up. During the separation of the marriage, or during the marriage, they were living in the wife's father's property. Due to the basically the separation of the family, the father of the bride gave them a notice to vacate the property. Can this be done is the question. Well, I don't have a lot of information in here. I have enough to understand that it appears that family members were living in another family member's home. And it's unclear from what the information I was given if they were paying rent or not paying rent, and that can make a difference of the law. However, it doesn't really make a difference in regards to the potential of what can happen. If they were paying, let's say, the father-in-law rent, the husband and wife, separated or not, would be considered tenants. And if they were paying monthly, the notice to vacate or to get out, if there was not a written lease saying it was for a year, but if they were just having a verbal agreement that you're going to pay month to month, then the 3-week notice primarily could suffice if it was given in the right proper time, which is 15 days prior to the net rent being due. So that is one way that's a proper notice. However, if they weren't paying rent and you were just father-in-law saying, hey, you need a place to stay, here's the house, you stay, there is no tenancy created. That means there is no agreement, verbal or written, of you have to pay me or do anything to stay in my house. I'm just being a nice family member saying, here, stay, which is really nice to stay for free. However, under that law, the father-in-law is correct. I can give you a notice, and it doesn't have to be 3 weeks. I can say give you a notice. I normally advise people to do it written, to saying, my generosity is over. It is time for you to leave. This happens a lot in families, and under that situation, since they're not tenants, since there's no payment to stay in the home, it is basically a notice to get out, is what I call it. It's a proper thing, and the father-in-law would have the right to go to court immediately upon the whatever expiration of the notice to get out occurs and file what's called an unlawful detainer. That's not an eviction. It is just the law under Statute 82 in the state of Florida that says sometimes you invite people in, they don't become tenants, and unfortunately, when the honeymoon period is over and I no longer want you to be my house guest and you don't leave and law enforcement is not going to kick them out, this is where you have to go get a court order that says that the court is saying that the original owner of the property has the right to leave and to relieve you of the property and make you leave. So I hope that helps this person in this scenario. If how it seems, if you are the people who are living there, I'm sorry, unfortunately, either way, you're going to be removed from the property. But one gives you more grounds and standing as a tenant, because if it is a year lease and he only gave you 3 weeks and that lease is not up and you haven't defaulted, you can fight it and say, I get to stay. But if it is simply a month or you're just a house guest, the notice is proper. Last but not least, in regards to the question I got into landlord-tenant matter, it was a question in regards to withholding rent. And it goes, if my landlord refuses to repair the plumbing, can I just withhold the rent? That is a great question. However, it depends, is once again the legal matter. If you have a lease for the property that you're renting. I advise you to read it over carefully. If you don't have a copy, get a copy. Leases can change who's responsible for repairing parts of the house. And that is sometimes the fine print that tenants don't look at when they sign their leases. The landlord can say, if it's over $50, I'm not paying for it. I don't have to pay for it. It's at my discretion. It can say, everything that goes wrong in the house, the tenant's going to be responsible for the repair. The standard Florida one has a checklist as to the tenant's going to pay or the landlord's going to pay for repairs or be responsible for it. If it's silent, then you fall back under Florida statute. And under Florida statute, plumbing is one of the criteria that the landlord is required to cover. If you have a plumbing issue, which could be a very serious issue for a tenant, you need to give a notice, a 7-day notice stating that, hey, I've told you and now I'm telling you again that I need the plumbing repaired. You have 7 days to fix this plumbing, or I have the right to withhold rent and or terminate the tenancy. Now, I always have to tell tenants this. You have to give the notice before you withhold the rent, and it needs to be prior to the rent being due. So don't come up and surprise people 3 days after, like, your 3-day notice is on your door, and then give them a notice. Your rent was already due. You need to be in good standing, current on your rent when you give these 3-day notices. That is just the best way to do it, and the actual legal way to do it, so you can actually properly have a defense. If the landlord still wants to go forward with an eviction, make sure you have a copy of the notice that you gave the landlord saying, you didn't do the plumbing, I withheld rent. I advise all tenants, when you do withhold rent, don't spend it. Hold it, because if the landlord does fix the plumbing, you owe them the rent. If it goes to court, the court will make a determination on how much the unfixed issue, plumbing per se, actually impacted your ability to live in the home and will reduce the rent, or there may not be any rent due. So I always advise people, just don't start spending the money. You may need to still have owed some rent to the landlord. Well, I have truly enjoyed this opportunity to spread some information and knowledge about the law of Florida to you. If you have any other questions, we will be doing Riggins Law Firm live every second Tuesday of the month. And you can go ahead and go to rigginslawfirm.com and submit your questions, so we'll be ready for next month's version of this. If you have any other legal matters or legal questions that you either need more assistance or actually need representation, also feel free to contact Riggins Law Firm to set up a consult. Have a great and blessed day, and happy holidays. Good day.
Amen.